well-regulated militias being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. I was hoping to actually do this a little bit later in the day so I could go out to Richmond, the state capital, this morning for the VCDL's Gun Owners Lobby Day. Unfortunately, I am stuck here at home waiting on a plumber to show up. So my apologies for not being out there. It was certainly my intention, but had a sort of homeowner-related emergency over the weekend. From what I can tell, we are not seeing the 40, 50,000 people that we saw in downtown Virginia in January of 2020, which was the last time Democrats had complete control of state government. But it does look like attendance is up considerably from what we've seen during what we saw during the Glenn Youngkin administration, where, some of the lobby days, you had maybe a few dozen people show up. I would say, and it's hard for me to tell based on just the photos that I've seen, certainly hundreds of folks in attendance. I would not be surprised if it ends up being several thousand individuals. And as Philip Van Cleve, head of the VCDL, said, Democrats are actually holding back some of the worst gun control bills until after today's activities are through. The deadline to file legislation is not until January 23rd. So we do expect that between now and the end of the week, we're going to see, the Senate's version of a bill banning so-called assault firearms and quote-unquote large-capacity magazines, permit to purchase legislation. There was another bill that, and I've been trying to keep track and update folks on all of the gun control bills that have been introduced to date at Bearing Arms. There was one that I missed, and we're going to talk about that in just a minute on the program. But the other big news of the week is not related specifically to Virginia. In fact, it's related specifically to Hawaii. But it does have implications for those of us who exercise our right to bear arms in all 50 states. The Supreme Court will hear oral arguments tomorrow in Wolford versus Lopez. This is the challenge to Hawaii's default ban on concealed carry on all private property. If you want to carry in any establishment or on anybody's property, you have to first explicitly receive permission to do so. Now, that flips the script on what things are like throughout most of the country, where the default is you've got the right to carry. If a property owner wants to exclude carry on their property, they can do so. That's their right. But in a nation, again, where our right to keep and bear arms is enshrined in the Constitution, we should default to that is allowed. And if it is not allowed, you need to specifically say so. Hawaii has, and its defenders, by the way, have expended a great deal of time and effort trying to refute the obvious, right? That, again, if we're talking about something that's a constitutionally protected right, the default should be you're allowed to do it. Look at signs, when you go into restaurants, no solicitors allowed, right? People put up signs on their property, no solicitations. Why do they need to put up a sign for that? Why isn't the default that solicitors aren't allowed? I would say it's because we have a First Amendment right, freedom of speech. And again, if you want to exclude that type of speech for your property, you're allowed to, but you need to make it clear that that is behavior and activity that is not permitted on your property. Same thing with concealed carry or open carry, I suppose, too. Although in Hawaii, I don't believe that open carry is allowed. I could be wrong about that. But anyway, the Supreme Court will take up the issue of Hawaii's vampire rule during oral arguments tomorrow. We expect to see a decision by the end of this term. Historically, Second Amendment cases have been some of the last decided by the court, so it could be mid to late June before we get a decision. And one of the ancillary issues here beyond the statute in question in Hawaii is the level of generality that courts are using to find historical analogs. And the Supreme Court has not said much about that, right? They've said that the laws don't have to be historical twins, that the law is not set in amber, But they haven't said, like, well, how close do these historical laws have to be in terms not only of the specific conduct that is being regulated, but the how and why those regulations exist. In Wolford versus Lopez, the state of Hawaii is basically pinning its case on two laws. One, a 1771 New Jersey statute that forbade carrying basically on improved land, taxable land, I believe it was, defined as, without the property owner or plantation owner's permission. The second law, a 1868 law from Louisiana, part of the Black Codes, that, again, forbade the carrying of firearms onto plantations unless you had the explicit permission of the plantation owner. And the Ninth Circuit said that those were dead ringers to Hawaii's law that bans concealed carry by default on all private property, not just farmland, but retail businesses, private residences, parking lots, any privately owned property. Dead ringers. Now, as the plaintiffs and their supporters have pointed out, that is absolutely not the case. Neither the New Jersey law nor the Louisiana law touched on carrying on private property in urban areas, retail establishments, things of that nature. It was related to regulating concealed carry on farmland or plantation land. In the case of the 1771 statute, it was pretty clearly designed to stop poaching, again, on improved land. Now, if you had 800 acres, 400 of that, you had felled the trees, you'd plowed the ground, you were raising crops there, nobody could carry on that property without your explicit permission. But the other 400 acres of unimproved land, actually, you could carry. Someone could carry on your private property as long as that land was unimproved. The Louisiana law, while racially neutral on its face, was applied disproportionately to those freed slaves who were exercising their Second Amendment rights. So both the how and the why, I think, differ from Hawaii's law. But this issue of the level of generality is going to come up. In fact, there was I know that there's been a brief, an amicus brief in Hamani. I think there was an amicus brief in Wolford versus Lopez touching on this issue. Daniel Schmutter actually sent me an amicus brief that is going to be filed in Schoenthal versus Raoul, which is the challenge to the ban on public carry in public transportation in Illinois. And again, what we see here in that particular case, along with Wolford versus Lopez, are these courts basically concluding that any law that has the slightest resemblance to a modern day statute, we can reason that those laws are analogous, right? In Schoenthal versus Raoul, the Seventh Circuit even went so far as to essentially create a new sensitive places designation. As Schmutter writes, by stitching together isolated historical outliers, the court conjured a sweeping prohibition on carrying in, quote, crowded spaces. And having determined that the appropriate balance favors banning firearms over the risk of allowing armed self-defense, by the way, a balancing test that you're not allowed to engage in, the Seventh Circuit Court of Appeal then generalized at whatever level of abstraction was necessary to justify the ban. And so I am hopeful that one of the outcomes in Wolford versus Lopez will not just be striking down Hawaii's vampire rule, but that the justices will provide more detail about how to employ the text, history, and tradition test. How specific a historical statute needs to be. Again, we know, the Supreme Court said in Rahimi that, laws aren't set in amber, that you don't have to have a historical twin, but maybe a kissing cousin. But again, that shouldn't mean that, okay, well, this law regulated the right to carry in some way, and so therefore every law regulating the right to carry today can be upheld as constitutional because there was, a regulation in place back in 1791 or in 1868. I don't know that the court is going to do that. I suspect that we will get something I also suspect, given the narrowness of the Supreme Court's decisions in Heller, McDonald, Bruin, and Rahimi, that the court will still leave a lot up for interpretation. I hope that that's not the case, but I suspect that it is. We will be talking a lot more about Wolford versus Lopez on tomorrow's Bearing Arms Cam and Company. I will probably wait until the oral arguments have concluded before doing tomorrow's show, so that way we can talk about what the justices said and read some tea leaves as to where we think the court is going to come down. At this point, I have to say I would be shocked if the court upholds the wise vampire rule. I just don't see that happening. To me, the question is, how broad is the decision going to be? And how much guidance does it offer in other challenges to sensitive places and gun-free zones? So again, we'll be talking about that on tomorrow's program. I do want to get back to Virginia for just a second. That bill that I mentioned earlier that I don't know if this just got added late to the Legislative Information Services database, if I just skipped over it. But, among the bills that we've seen to date are bills expanding the red flag law in Virginia, who can apply for a red flag petition. You've got the House version of a ban on so-called assault firearms and large-capacity magazines. You've got a bill that would impose a $500 tax on the sale of all suppressors in the state of Virginia. You've got bills that would make it easy to sue not just gun makers and firearm retailers, but even the makers of accessories if that accessory is attached to a firearm that's used in a crime. And again, we know what's coming. A permit to purchase bill likely to come. Senate version of the so-called Sullivan ban, or assault firearm as it's called in Virginia. But this other bill that we're going to be talking about today, it's HB 907. And it deals with firearm retailers in the Commonwealth. For the purposes of this section, a retail mercantile establishment is any place where merchandise is displayed, held, stored, or offered for sale to the public, but it does not include any location that also serves as a private residence. So if you are an FFL, you operate out of your home, this bill does not apply to you. For now, anyway. But if you operate a brick and mortar location, then it does apply to you. And what HB 907 says is that no dealer in firearms operating from a retail mercantile establishment and holding a valid federal firearms license issued by the Bureau of Alcohol, Tobacco, Firearms, and Explosives may conduct business and store firearms at a location unless, 1, the premises on which the dealer in firearms operates is equipped with security features, including A, equipment capable of filming and recording video footage inside and outside buildings where firearms are stored, and B, at least one of the following security features designated to prevent an unauthorized entry is installed on all exterior doors and windows of all buildings where firearms are stored. So you've got to have that video surveillance. By the way, the bill doesn't say how long that surveillance footage has to be stored, anything of that nature. You basically just have to have a camera there. Or even that it has to be, the footage needs to be stored at all. Now, again, that's all subject to amendment during the legislative process. But in addition to those cameras, you have to have at least one of the following security features that, quote, designed to prevent unauthorized entry installed on all exterior doors and windows of all buildings where firearms are stored. Either bars, security screens, commercial-grade metal doors, grates, or other physical barriers approved by the Superintendent of State Police, a burglary alarm that is continually monitored, and if practicable, physical barriers designed to prevent the use of motor vehicles to breach any buildings where firearms are stored. So it is conceivable that with cameras and a burglary alarm, an FFL could continue to operate. My concern is that the or is going to be replaced by an and that FFLs will be required to impose these physical barriers to their buildings. in some cases, that might not even be possible. Most FFLs do not own the building where they operate, or at least many of them don't. They lease that, right? And it may not be possible for them to add those types of security features. Excuse me. Their landlord might not let them do it. In terms of their lease, might not allow them to do it, to make those types of changes. So I think this in itself could prove problematic. If the bill stays as is, it's going to be an extra expense for FFLs, no doubt about it. But you could get away, I think, with again a burglar alarm and the installation of those cameras. I'm just not convinced that this bill is going to remain as is throughout the legislative session. Now, what about the penalty for this? This is where it gets weird. In addition, before we get to that, there is another provision. Outside business hours, the dealer in firearms is supposed to lock up all firearms stored on the premises in either a vault, a safe, or a room or building that meets the requirements under subdivision 1. So with all those security features. So now this is, again, going to be problematic for FFLs because you can't leave any of your inventory out, right? Let's say you've got your pistols in a, locked glass case there in your store. At the close of business every day, you're expected to take those firearms out of that locked glass case, store them in a vault, store them in a safe somewhere, even if you have all of those security features in place. So you can have the burglar alarm. You can have the video surveillance system. You could even have bars on the doors. But under this bill, you would still be required to take your entire inventory of firearms, lock it up in a safe somewhere. Obviously, this is going to impact high volume dealers more than smaller FFLs. I'm trying to think of like how Bass Pro, for example, is going to operate under a provision like this. But again, it's another expense, and it's one that it's a barrier that some FFLs might not be able to meet. And frankly, again, I think with all of the additional security requirements that the Democrats want to put in place, I would think that it would be needless to require you to, again, take all of your inventory and lock it up in a safe at the end of the night. But the really weird part about this is the penalty for violating the law. And I can't figure out what it is, quite honestly. So Section C of the bill says a person who violates the provisions of subsection A is subject to a civil penalty not exceeding $1,000. This subsection does not apply if the security features required pursuant to subsection B become temporarily inoperable at no fault of the dealer in firearms. And then right after that, notwithstanding the provisions of statute, any person convicted of a first offense for willfully violating the provisions of this chapter is guilty of a Class 2 misdemeanor. And any person convicted of a second or subsequent offense under the provisions of this chapter shall be guilty of a Class 1 misdemeanor. So, what is it? Is it a civil fine punishable by $1,000? Or is it a criminal misdemeanor punishable by jail time and a fine of several $1,000s? I can't figure it out. And all this, of course, again, is subject to change as the legislation makes its way through committee and onto the House floor. If it makes its way through committee and onto the House floor, and I have to say, again, with a veto-proof majority in the House, a supermajority of Democrats in the House of Delegates in Virginia, I expect the vast majority, if not every single anti-gun bill that's introduced in the House, to get to the House floor for a vote. The Senate in Virginia, more narrowly controlled. Senate Democrats have essentially a one-seat advantage. It's 21-19 in the state Senate. But that's all that they need. And what we've seen to date is that the Senate Democrats are marching in lockstep with one another. And I suspect that is going to be the case with the vast majority of gun control bills that have been introduced in the state so far, and those yet to come as well. It is a new day in Virginia and a dark new day when it comes to our Second Amendment rights. So we will continue to follow this particular bill as well as the dozens of other gun control bills that have been filed or will be filed by the end of this week. But I would also encourage you, if you are a Virginia gun owner, join VCDL, join the Virginia Shooting Sports Association. Make sure you're signed up for, legislative alerts from the National Rifle Association, from Gun Owners of America. There is, if you're a Virginia gun owner, this is it, man. I mean, there's no excuse not to be involved. Even if you couldn't make it down to lobby day today, like me, you can pick up the phone. You can contact your state delegate. You can contact your state senator, even if you know they're not going to listen to you. I think it's important that those calls be registered, that the opposition greatly outnumber supporters for these bills. And that's not going to happen if we stay silent or we stay on the couch. It's just not. So it is now time to get involved, and it is necessary to get involved. Even if ultimately a lot of these things end up being signed into law and are challenged in court, that doesn't mean that we can just, again, keep our mouths shut while our rights are being infringed. All right, on to today's Armed Citizen story, our good deed of the day, and our recidivist report. We'll start there. And this is not really a true recidivist report. I guess this is a first offense. God, I hope so. But it is a disturbingly light potential sentence. A judge has not yet signed off on this, but this is the plea deal that was offered to the former mayor of Madison, Indiana, who's also, by the way, a former school resource officer, after he pled guilty to attempted child exploitation. This is really disturbing. Tim Armstrong is this guy's name. He entered a plea agreement last Friday morning in Jefferson Circuit Court, pleading guilty on 2 counts of attempted child exploitation and official misconduct. The judge took the plea agreement under advisement. Sentencing is scheduled for March 16th. Armstrong was a school resource officer. He was a high school baseball coach with the Madison Consolidated Schools at the time of the incident that led to the charges, which stemmed from incidents with a 12-year-old that occurred between April and May of 2022, in which a sexually explicit communication was made by Armstrong. So, attempted child exploitation is a level 5 felony. So Armstrong is pleading guilty to a felony. The plea agreement that he signed would sentence him to 4 years incarceration, with all 4 years suspended to probation. On the charge of official misconduct, which is a level 6 felony, Armstrong would be sentenced to 1 year incarceration. And again, the entirety of that sentence suspended to probation. The plea agreement provides for both counts to run consecutive for an overall sentence of 5 years. But again, all time suspended to probation. So if Armstrong stays out of trouble, then he doesn't go to prison for attempting to coerce a child into sexual activities. He would be required to register on the sex offender registry for a period of 10 years. But these are the charges that he pled guilty to. The 11 charges that he originally faced included child seduction, promotion of child sexual trafficking, vicarious sexual gratification, and child solicitation charges. Rick Hurdle is the Ripley County prosecuting attorney who took over prosecution of the case. He said, in discussions with the victim's father, he would have liked for Armstrong to have served prison time, but it says the case came down to the evidence and, quote, what is admissible and what is not admissible. Without any more specifics, we kind of have the DA, we have to take the DA at his word. I would say, however, that Mr. Armstrong accepting this guilty plea certainly suggests that he was concerned that if this case went to trial, he would be convicted, regardless of the prosecutor's concerns over the admissibility of particular evidence. And, I'm frankly, I'm with the victim's father. I don't like the fact that somebody who is trying to sexually exploit and sexually assault, ultimately, a 12-year-old who'll be able to walk away with nothing more than probation. Now, on to today's armed citizen story from Killeen, Texas, where police are investigating a shooting that happened over the weekend. It looks like it started out as a domestic assault, and then an armed citizen ended up intervening and shooting the man who was getting violent here. Happened Sunday afternoon, about 1:30 in the afternoon. Officers found a man outside of a home, suffered from multiple gunshot wounds. He was taken to a local hospital and died there at that facility. According to Killeen police, a 45-year-old woman also received medical attention. She was brought to another hospital with non-life-threatening injuries. Officers say that witnesses heard a woman screaming, saw a man pointing a gun at her. A 66-year-old man who was walking in the area, just happened to be there, said he heard what was happening and intervened. When he saw the 58-year-old man pointing his gun at the woman, that's when the 66-year-old man, who was lawfully carrying his own firearm, drew his handgun, shot at the 58-year-old. The case is being reviewed by the Bell County DA's office. No arrest made at the time. And, again, if the witness statements match the evidence, I don't think any charges will be filed, because you are allowed in Texas to not only protect yourself, but to intervene and protect the lives of others as well. And it sounds like that was what was happening here. If somebody is pointing a gun at somebody, and it sounds like this, again, wasn't a case where the 58-year-old man had drawn his firearm in self-defense and said he was being aggressive towards this woman, then, yeah, that does give you reasonable belief that her life is in danger, and you have legal justification to act under those circumstances. Finally, today, our good deed of the day, in the right place. And not that that wasn't a good deed. I think it is going to turn out to be a good deed, but in the right place at the right time, willing and able to do the right thing. A UPS driver among the Good Samaritans who helped a 101-year-old woman escape her burning home in Orange County, California. This was just a couple of days ago, January 15th. Neighbors saw heavy smoke coming from Ann Edwards' condo, no relation, by the way. At that point, smoke had already filled the kitchen. That set off the fire alarm. Neighbors started pounding on the front door. One neighbor grabbed their fire extinguisher to try to help smother the blaze. Another grabbed a garden hose, climbed up a ladder, was spraying water into the kitchen vent from the roof while the flames are underneath them. Ann Edwards, 101, lives on her own, confused and reluctant to leave. So neighbors ended up calling over a UPS driver who happened to be nearby, and he actually went inside the home, picked Ann up, carried her safely outside. Ann's son, Rick, told KTLA he got her out of there using his strength. By the time the Orange County Fire Authority arrived, heavy smoke in the condo. Rick Edwards said they could barely see when they opened the door. The blaze actually spread at that point into the attic, but they were able to get that under control. They ended up transporting Ann Edwards to a local hospital for evaluation. Her son Rick says he's grateful to Ann's neighbors for acting quickly, as well as to the UPS driver whose identity wasn't released. He said, "Thank you, because I bet it took a little bit to get my mom out of there. She didn't want to go. And I can tell you that you probably had to use a little force, but God bless you, man, for sticking with her and getting her out of there. Thank you." Mom apparently is still in the hospital, is expected to recover, still a little confused about everything. And I would say at 101, Ann Edwards' days of living alone might have come to an end, but her days of living have not, because of the actions of those neighbors and that UPS Good Samaritan. So in the right place at the right time, willing and able to do the right thing. We thank you for your very good deed. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I do want to thank you for being a part of the program, as always. Looking forward to seeing you back here again tomorrow. And again, we'll be breaking down the oral arguments in Wolford versus Lopez, a very big day at the Supreme Court. We've got another one coming up with U.S. versus Hamani, oral arguments taking place in March in that case. But all eyes on SCOTUS and the vampire rule that Hawaii has put in place. And again, we'll have a full coverage for you on tomorrow's Bearing Arms Cam & Company. Be sure to check out BarionArms.com throughout the day today, keeping you up to date on all the latest Second Amendment news and information from all across the nation. And if you like what you see, I would encourage you to become a VIP Gold, or VIP Platinum member. Just use the promo code FIGHT, and you can get 60% off whatever level of membership you choose. Great benefits at every tier of support. And again, no matter which tier you choose, you will be supporting the independent pro-Second Amendment journalism that we're doing at Barion Arms, and I thank you very much for that. Enjoy the rest of your Monday, as well as Mondays can be enjoyed. And I'll see you back here again tomorrow. Until then, be well, be safe, and be free.